Friday the 16th of December and it's 7 o'clock in the morning, and I'm heading to Carlow now to the Workplace Relations Commission. It's a case involving allegations of discrimination by the employee against the employer. On this occasion I'm for the employer. I act for both employee and employer, but on this occasion, as I say, I'm for the employer. So we'll have a look and hopefully it'll go well. I'm fairly well prepared, but you never know how these things will go, and you're just always hoping that you're never going to be blindsided out of left field with some question or something that you might have overlooked. So hitting the road now. So I'm in Carlow here in the Workplace Relations Commission car park. I'm way too early as usual. It's only 8:30 and I'm not meeting my client for another half hour or so. But basically it's a discrimination case where the employee is alleging discrimination. Now, the first thing that the employee will have to do is make out a prima facie case that he was discriminated against. So the probative burden is on the employee to show that there is a prima facie case, and to do this he needs to show acts from which an inference of discrimination can be drawn. If he can do that, well then the probative burden, the burden of proof, shifts to the employer, and then me or my client will have to discharge that burden and basically prove that there were no acts of discrimination. Now, my understanding is that this employee is representing himself, and whilst any employee can bring a claim to the Workplace Relations Commission and they can run the case themselves, some of the laws can be quite technical, and there are certain proofs that will be required in order for him to win his case. And the Employment Equality Act 1998 and various other bits and pieces of legislation kind of set out the requirements. They will provide definitions of discrimination. They will make provision for comparators. In other words, it's not enough to say that you are a member of one of the 9 categories that's considered a discriminatory category or a protected category in discrimination legislation, and that you've been treated differently. That's not enough, because that could be a coincidence. In other words, the way you're treated could have been the way that a person who was not in one of those 9 categories would have been treated in the same circumstances. So it's not enough to merely say that you're a member of, say, the travelling community, or that you have a certain family status, or that you are a particular of a particular race, and therefore you have been discriminated against. You do have to prove acts of discrimination. So, as I said, an employee can bring a case to the Workplace Relations Commission, but if they fail to discharge some of the technical proofs required to win their case, then they may regret later on that they didn't actually get a solicitor or a legal professional to help them and to represent them, because just because you can do something doesn't mean that it's a good idea. And I have put quite a bit of work into this case, as I do, I suppose, into all the cases that I deal with. I mean, obviously I do my best every time, whether it's the employer I'm for or whether it's the employee, but the bottom line is that I've gone through the legislation fairly carefully, fairly closely, and I know what the employee needs to do to win his case, and quite frankly I don't think he can do it. And if he doesn't, I'll be pointing out to the Workplace Relations Commission adjudicator that he has simply failed to make out his case, and that his claims of discrimination are not well founded. But we'll see later on. Maybe he'll win his case. Maybe I'll lose. That's the way these things go. You know, there's only really 2 outcomes: you can win or you can lose. So we'll see later on. 3 hours later now, and it's certainly a long one. It went on from 10 o'clock to 1 o'clock. When there's an interpreter involved, it's always pretty slow. I think it went fairly well, but you never know. You never know. So it's entirely down to the adjudicator now to decide whether my clients did discriminate against the employee or not. It was slow and it was tedious and it was a bit frustrating, because when there's an interpreter involved, it really is time consuming, because everything has to be really related or recounted twice. But that's the way. Hoping for the best now.
I'm back in the office now, and just something that I forgot just to mention there earlier on. A funny thing happened at the end of the adjudication process. The adjudicator invited both sides, the complainant and respondent, to make closing submissions, and the complainant asked the interpreter to read out something off the internet, and it was, in fact, the minute he started reading it, I recognised this because I wrote it. He was actually reading off a page from one of my websites, employmentrightsireland.com, in fact. So it was a unique situation insofar as that was the closing submission. So I had a closing submission to do then for the respondent. So in fact, you could say that I actually did the closing submission for both complainant and respondent, which is a unique sort of a situation to be in. But you never know when your stuff is going to pop up and appear in wherever. Now, he even attributed my name to the writing. It's off a page on my website, Employment Rights Ireland, but as I say, it is unusual, and I don't know what he intended or hoped to gain by it, but it was an unusual situation. But as I say, the minute he started reading it, I recognised it as my own words, my own writing.
Okay, it's the middle of February now. It's 15th or 16th of February, and we finally got the decision back from the WRC. I just have to cover this up because until the decision is published on the Workplace Relations website, it's not for publication generally. But basically, we've got the decision back from the WRC, and the decision of the adjudicator, thankfully in this case, is that he finds that on each of the 4 grounds of alleged discrimination under the Employment Equality Acts, that the complainant has failed to establish a prima facie case of discrimination. And that being the case, then the probative burden, the burden of proof, does not shift from him to my client, the employer. It stays with him. He has failed to discharge that burden of proof. He has failed to establish facts from which an inference of discrimination could be held, and therefore the adjudicator has found in favour of the respondent on all 4 counts. So that's good news. Just now it happened like that, but thankfully that's the decision. So that's how one day at the WRC can eventually end up a number of weeks later, a good few weeks later actually, because I did this before Christmas and started the video actually before Christmas and did it in 3 little sections. So there you go. Hope you find it useful. If you do, please give it a thumbs up down below on YouTube, or subscribe, or on Facebook. Just give it a thumbs up and let me know if you like this type of video, and maybe even comment and let me know what type of video you do like, whether it's educational or instructional or stories or whatever. Thanks a lot.